Alex here with part 14 of the My Docket series on Corazon real estate. As my previous videos, please take a look at part 0 if you haven't seen it yet. Going into my mindset, I really can't. Actually, I probably can. So this is I guess what the Corazon real estate called opposition to arbitration, which did make me chuckle for sure because that's not how that works. Um, so I can see what's going on. The Corazon real estate CEO guy is just recognizing patterns, which is pretty much how I kind of learned in the beginning too. And in fact, probably how most people would learn the legal process if they're not an attorney and they're not in school. In fact, I know I talk about this in some of my videos where you're just in a reaction mode and somebody files something and then you figure, okay, I need to oppose it or respond or something like that. In Nevada, the Nevada arbitration rules control how cases are assigned to the court annexed arbitration program. And you really have to file one of two things, either the request for arbitration or the notice of exemption from arbitration or something like that. And if you are requesting arbitration, then you're just conceding that the case's jurisdiction is going to be, or sorry, that the monetary award is going to be below $50,000 threshold. And then if you're trying to exempt from arbitration, you are supposed to point out precisely why the case shouldn't go to arbitration. And it's either because the dollar amount could possibly be over $50,000, or I believe there are other ways, like if the court's going to need to issue injunctions or other complicated things like that that are not within the arbitrator's power. So the CEO, Charles Chinnici, just knee-jerk reaction saw me trying to do something, and then he assumed that he needed to stop it, which is silly because the court annexed arbitration program is one of the mechanisms in place to simplify the process in district court that would otherwise be pretty lengthy, pretty convoluted, pretty thorough. And it's kind of, in a way, it's the sort of small claims analogy in justice court. If small claims in justice court is to civil action in justice court, as arbitration, court annexed arbitration in district court is to just an ordinary lawsuit in district court. And so he didn't realize that he was actually making things worse. I mean, if the case went to just ordinary, if the case didn't go into court annexed arbitration, that would actually be sort of going in the direction of the evil litigant who's trying to make him spend as much money as he possibly can. So he doesn't realize that he's arguing in the wrong direction. He doesn't realize he's taking the wrong position because he's just has this knee-jerk reaction that whatever I'm asking for, he needs to do the opposite. And so I hope that makes sense to you guys. I hope it's not complicated. If it is, take a look at my other video, because I'm pretty sure that I have a legal nuts and bolts video on the court annexed arbitration program, and I go into detail as to what that is and what the point of it is. And obviously, a person who is complaining about the legal process being confusing and expensive is going to want to go into court annexed arbitration. They're not going to want to avoid it. And if I was trying to drag it out and make it as expensive as possible for him, then I would have, concocted some scheme as to why I am exempt from the court annexed arbitration program. In fact, I have a pretty plausible basis. I could have probably said that the punitive damage award can go as high as $300,000, and therefore I should be exempt from arbitration. I could have said something like that if I really wanted to be as evil as he's trying to make me out. And I didn't do that because I just didn't think that the company made that much money where a $300,000 award would make sense. I thought that his company made a substantial amount of money, but I didn't think it would be such a huge amount of money that a jury would award over $50,000. I just didn't think that it would happen. And so I was just being true to myself and being honest and saying this should go to arbitration because I don't think it's going to be possible for the award to be that high. I think all that being said, we should go ahead and take a look at what the landlord has filed. What Charles Chinnici has filed. Here we have Charles Chinnici's opposition to plaintiff's request for arbitration. Scrolling down. Standard introductory paragraph, he's indicating that he's appearing for his corporation, improper person, that he's filing his opposition to my request for arbitration. We have... Okay, hold on a second. All right, so same thing, guys. I'm not going to go through copy paste. If this is copy paste, I'm just going to skip over it. And I know he's brought this up in the last opposition that we covered in the last video. Looks like same thing. Same thing. Same. It looks like it's just a clone of his it's a clone of his reply to opposition to motion to dismiss. It looks like it's a verbatim clone. Okay, so affidavit indicating that the facts alleged in this document are true and correct. Rule 5 certificate of service indicating he mailed this to me. And that's it. So yeah, sorry guys, I didn't know it would be a complete and total clone of his last filing. Standard policy of the My Docket series is to not go over things more than once. You can always go down into the description below, click on the link for yourself, download it, take a look. And if you think that I missed something, that I should have brought something up, just go ahead and mention it down in the comments and I will go ahead and do that. Let's move on though. And we are now going into the aftermath. I didn't file anything, so I incurred $0 in costs. Charles Chinnici filed the opposition, but it is a free filing, so he incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. He's going to eventually be forced to get an attorney, and I think they would have probably reviewed this for at most 15 minutes, which at the rate of $250 an hour is going to come to $62.50 in attorney fees for the for Charles Chinnici for Corazon Real Estate. So as my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.